Good morning. Please be seated. The court meets today to hear the oral arguments of the parties on the merits in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, Croatia versus Serbia. Since the court does not include upon the bench a judge of the nationality of either of the parties, both parties have availed themselves of the right under Article 31, paragraph 2 of the statute to choose a judge ad hoc. The Republic of Croatia chose Mr. Budislav Bukas, and Serbia chose Mr. Milenko Kreća. They were duly installed as judges ad hoc in the case on 26 May 2008 during the hearings on the preliminary objections raised by the respondent. I shall now recall the principal steps of the procedure so far followed in this case. On 2nd July 1999, the government of the Republic of Croatia filed in the registry of the court an application instituting proceedings against the Federal Republic of Yugoslavia in respect of a dispute concerning alleged violations of the Convention on the Prevention and Punishment of the Crime of Genocide adopted by the General Assembly of the United Nations on 9 December 1948. To found the jurisdiction of the court, Croatia invoked Article 9 of the Genocide Convention. By an order dated 14 September 1999, the court fixed 14 March 2000 as the time limit for the filing of the Memorial of Croatia and 14 September 2000 as the time limit for the filing of the Counter Memorial of the Federal Republic of Yugoslavia. At the request of Croatia, these time limits were successively extended to 14 September 2000 and 14 September 2001, and then again, at the request of the applicant, to 14 March 2001 and 16 September 2002, respectively. On 11 September 2002, within the time limit set in Article 79, paragraph 1 of the Rules of Court, as adopted on 14 April 1978, the Federal Republic of Yugoslavia raised preliminary objections relating to the court's jurisdiction to entertain the case and to the admissibility of the application. Consequently, by order of 14 November 2002, the court noted that by virtue of Article 79, paragraph 3 of the Rules of Court, the proceedings on the merits were suspended and fixed 29 April 2003 as the time limit for the presentation by Croatia of a written statement of its observations and submissions on the preliminary objections raised by the Federal Republic of Yugoslavia. Croatia filed such a statement within the time limits thus fixed. Public hearings were held on the preliminary objections from 26 to 30 May 2008. By its judgment on 18 November 2008, the court rejected the first and third preliminary objections raised by Serbia. It found that the second objection, that claims based on facts or acts and omissions which took place before 27 April 1992, that is the date on which the Federal Republic of Yugoslavia came into existence as a separate state, lay beyond its jurisdiction and were inadmissible. So this objection did not, according to the court, in the circumstances of the case, possess an exclusively preliminary character and should therefore be considered in the merits phase. Subject to that conclusion, the court found that it had jurisdiction to entertain Croatia's application. By an order dated 20 January 2009, the court fixed 22nd March 2010 as the time limit for the filing of the Counter Memorial of Serbia. The Counter Memorial filed on 4 January 2010 contained counterclaims. At a meeting held by the President of the Court with the representative of the parties on 3 February 2010, The co-agent of Croatia indicated that her government did not intend to raise objections to the admissibility of Serbia's counterclaims as such, but wished to be able to respond to them in a reply. The co-agent of Serbia stated that in that case his government would wish to file a rejoinder. By an order dated 4 February 2010, the court directed the submission of a reply by Croatia and a rejoinder by Serbia concerning the claims presented by the parties, and fixed 20 December 2010 and 4 November 2011 as the respective time limits for the filing of those pleadings. The court also instructed the registrar to inform third states entitled to appear before the court of Serbia's counterclaims, which was done by letters dated 20 February 2010. The reply and the rejoinder were filed within the time limits thus fixed. On 16 January 2012, at a meeting held by the President of the Court with the agents of the parties, the co-agent of Croatia stated that her government wished to express its views on Serbia's counterclaims in writing a second time in an additional pleading. By an order dated 23 January 2012, the Court authorized Croatia to submit such an additional pleading and fixed 30 August 2012 as the time limit for its filing. Croatia filed that pleading within the time limit thus fixed, and the case was ready for hearing. At a meeting held by the President of the Court with the representatives of the parties on 23 November 2012, it was decided the parties would negotiate with a view to communicate to the Court by late March or early April 2013 their common views and points of agreement on the organization of the hearings in the case. By a letter dated 16 April 2013, Croatia informed the Court that the parties had concluded an agreement on the methods of examining witnesses and expert witnesses. That agreement, as amended subsequently with the permission of the Court, provided inter alia that each party would submit to the Court, not later than 1 October 2013, a list of witnesses and experts that it wished to call, together with their authentic written testimonies and statements, if such testimonies and statements had not been annexed to the written pleadings. Each party would then communicate to the Court, not later than 15 November 2013, the name of any witness or expert called by the other party that it did not wish to cross-examine. It was further agreed that the written testimonies and statements would replace the examination in chief. On 1 October 2013, the parties communicated to the Court information concerning the persons whom they intended to call at the hearings, as well as the written testimonies and statements which had not been previously appended to their pleadings. Croatia stated that it wished to call 9 witnesses and 3 witness experts in support of its claims. For its part, Serbia announced that it was planning to call 7 witnesses and 1 witness expert in support of its counterclaims. By a letter dated 15 November 2013, Croatia informed the Court that it did not wish to cross-examine the witnesses and the witness expert announced by Serbia, on the understanding that they would not be called to testify before the Court, and that their evidence to the Court would be in the form of their written testimonies or statements. Croatia added that if this understanding was not correct, or if the Court itself wished to put questions to Serbia's witnesses or witness expert, it reserved the right to cross-examine them. By a letter of the same date, Serbia informed the Court of the names of the 5 witnesses and 1 witness expert of Croatia, that it did not seek to cross-examine, and indicated that it wished to cross-examine the other 4 witnesses and 2 witness experts announced by Croatia. At a meeting held by the President of the Court with the agents of the parties on 22 November 2013, the parties agreed inter alia that there was no need to have witnesses and witness experts come to the Court if they were not to be cross-examined, unless the Court itself wished to put questions to them. By letters dated 16 December 2013, the registrar informed the parties inter alia that at this stage of the proceedings the Court did not wish to question the witnesses and witness experts that the parties were not intending to cross-examine. At the same time, he further informed them that the court wished to receive certain additional documents concerning the witness and witness experts, and that Serbia would have an opportunity to file written observations on a document requested of Croatia. By a letter dated 14 January 2014, Serbia provided the court with the documents requested. By a letter dated 31st January 2014, Croatia communicated to the court the requested document. By a letter dated 11 February 2014, Serbia indicated that it did not wish to present written observations on the document provided by Croatia. By a letter dated 17 January 2014, Croatia asked the court to take certain protective measures for two of its witnesses, consisting in particular of hearing their evidence in closed session and referring to them by pseudonyms. By letters dated 7 February 2014, the registrar informed the parties that the court had decided that the parties should use pseudonyms when addressing the two witnesses for which Croatia had asked for protective measures, or when referring to them, and that these witnesses would be heard in a closed session of the court with only registry staff and members of the official delegations of the parties being permitted to attend that examination. The parties were also informed that the court had decided to impose the following measures to ensure the integrity of the testimony statements of the witnesses and witness experts. 1. The witnesses and witness experts would have to remain out of the court both before and after their testimony statement. 2. The parties would have to ensure that the witness experts would not have access to the testimony statements of other witnesses, witness experts before the end of the oral proceedings. The parties would have said further to ensure that the witnesses and witness experts would not be otherwise informed of the testimony statements of other witnesses, witness experts, and that they would have no contact which could compromise their independence or breach the terms of their solemn declaration. And 4, the public could attend the witness examinations, except the closed session, but would be requested not to divulge the content of the testimony statements before the end of the oral proceedings. The same would apply to representatives of the media, who would have to subscribe to a code of conduct under the terms of which they would be allowed to take photographs and make sound recordings on the express condition that they did not make public the content of testimony statements before the end of the oral proceedings. Regarding the publication of the written testimonies of witnesses and written statements of witness experts who will appear before the court, and the publication of the verbatim records of the hearing of these witnesses, witness experts, the parties were advised that this would take place at the end of the oral proceedings in their public versions with redacted passages concerning the protected witnesses. As to the written testimonies of witnesses and written statements of witness experts announced on 1st October 2013, but who will not be coming to the court to be cross-examined, the court intends to publish them on its website at the end of the oral proceedings, with a mention that the parties did not wish to cross-examine these witnesses and witness experts. A few of these written testimonies will be published in a redacted form or under pseudonyms. Lastly, on the question of the broadcasting of the hearings, the parties were notified in the same letters that the court has decided that while oral arguments will be broadcast on the internet, the examination of witnesses and witness experts, protected or not, would not. Having ascertained the views of the parties, the court decided, pursuant to Article 53, paragraph 2 of its rules, that copies of the pleadings and annexes would not be made accessible to the public immediately on the opening of the oral proceedings. The court considers that more information is required to decide exactly whether some of these documents should be redacted and to what extent, or possibly withheld from publication, to protect personal information relating to a number of individual victims and witnesses. In any case, the annexes to the pleadings, which contain written testimonies on disputed events in this case, will not be made public in any form until the end of the oral proceedings. In addition, to ensure the protection of any information that should possibly be kept confidential, the court has decided that a number of individuals will be referred to in public sessions by the annex number of their witness testimony, or casu quo by their pseudonym. I know the presence at the hearing of the agents, counsel, and advocates of both parties. In accordance with the arrangements on the organization of the procedure, which have been decided by the court, the hearings will comprise a first and second round of oral argument by the parties. The first round of oral argument will begin today. Croatia will have 6 sessions of 3 hours each, 5 sessions to present arguments on its own claims, the last one being on Friday, 7th March 2014, and 1 session to respond to Serbia's counterclaims on Tuesday, 18 March 2014 at 10 a.m. Serbia will begin its first round of oral argument and will have the same number of sessions as Croatia, that is 6. Its first round of oral argument will end on Friday, 14 March 2014. The second round of oral argument will begin on Thursday, 20 March 2014 at 10 a.m. Croatia will have 2 sessions of 3 hours and 1 session of 1.5 hours to present arguments on its own claims, the last one being on Friday, 21st March 2014 at 3 p.m. Croatia will then have 1 session of 1.5 hours to respond to Serbia's counterclaim on Tuesday, 1st April 2014 at 10 a.m. Serbia will begin its second round of oral arguments on Thursday, 27 March at 3 p.m. It will have 3 sessions of 3 hours, the last one starting on Friday, 28th of March at 3 p.m. In addition, I note that during the first round of Croatia's oral argument, the court will hear the witnesses and witness experts called by Croatia, which Serbia wished to cross-examine. These witnesses and witness experts will be heard at 2 public hearings on 4th and 5th March from 3 p.m. to 6 p.m., as well as in 1 closed hearing. They will be cross-examined by Serbia and re-examined, if need be, by Croatia. Members of the court may also ask them questions. Croatia, which will be heard first, may, if so required in this first sitting of oral argument, avail itself of a short extension, I would say up to 20 minutes, beyond 1 p.m., in view of the time taken up by my introductory words. I now give the floor to the agent of Croatia, Professor Vesna Crnjić-Grotić, to start, to open. You have the floor, madam.
Good morning, Mr. President, members of the court. I am honored to appear before the court on behalf of Croatia in the case against Serbia, all the more so on a case that raises such important issues under the Genocide Convention. Croatia is committed to the rule of law and believes that a just decision by the court will reinforce peace and stability in the region, contribute to the healing process for all involved, and support the purposes of the 1948 Convention. Mr. President, members of the court, Croatia initiated these proceedings in 1999. At that time, Slobodan Milošević was still in power in Serbia, the man who was the mastermind behind the conflict and atrocity that tore apart the former Yugoslavia. You will be aware that Mr. Milošević was charged with genocide, crimes against humanity, and war crimes before the ICTY. He died in 2006, avoiding conviction for any of those crimes. When Mr. Milošević was removed as President of Yugoslavia in 2000, and the new government was established, Croatia immediately engaged in negotiations with the aim of achieving a just solution with regard to the many issues left open after the war. Amongst those issues was that of the people still missing, a decade or more after the atrocities came to an end. Despite Croatia's efforts, many political leaders in Serbia have maintained an attitude of denial. It is to our great regret that this persists today. The current president of Serbia, Mr. Nikolic, has recently given interviews in which he has refused to recognize the events in Srebrenica as being genocide, despite the clear verdict of this court. His statement is in your folders at tab 2. It is the kind of approach which means that this case has proceeded. Nor has Mr. Nikolic repudiated his connections with Vojislav Šešelj, indicted at the ICTY, and the paramilitary groups with which he has been associated. Such an unfortunate comportment explains why we are here today. Croatia's only resort to justice appears to be this court, which has an important role. This court is the guardian of the 1948 Convention, and this court is uniquely placed to address facts and state the legal principles in a manner that is authoritative and final. No other court or tribunal has the possibility, not the national court, not the ICTY. Serbia takes refuge in the fact that the ICTY prosecutor has not brought charges of genocide for facts that are before you in these proceedings. Does that mean that no genocide was committed? Or that there was no failure to prevent genocide? Of course not. It means only that the ICTY prosecutor chose, in its exercise of prosecutorial discretion, to adopt the approach it did. You are the first international court to decide whether the terrible acts committed in and around Vukovar and elsewhere on the territory of Croatia were genocidal. We do recognize that Serbia at one time showed a willingness to bring prosecutions against responsible persons on its territory. Some efforts were taken, some proceedings brought, and convictions obtained. Yet the more recent developments are deeply unsettling. A Serbian war crimes chamber convicted 14 perpetrators of the massacre in Lovas, of which you will hear more this week, where a great many people were killed and exposed to the worst genocidal acts. Yet the Supreme Court quashed the judgment in January this year and ordered a retrial. Similarly, the judgment in the case concerning events in Vukovar was overturned by the Constitutional Court of Serbia last year. Mr. President, members of the court, undoubtedly courts in all states have a duty to protect the human rights of defendants in criminal cases. But these two cases cast a long shadow over Serbia's commitment to justice and the rule of law. We note too that no senior army officer has been indicted, as if the armed forces acted without orders from the top. Mr. President, members of the court, you will now on your screens see the results of what happened in Vukovar, a video taken in late November 1991, after the city succumbed to the attacks of the Yugoslav People Army, the JNA, and its allies. Please show the video. These images show what we are dealing with in this case, the result of an intention to destroy a part of a group. Over the course of the coming days, Croatia will show that its claims under the Genocide Convention are well-founded. Croatia still has no information on the whereabouts of the remains of more than 840 Croatian citizens still missing as a direct result of the genocidal acts. In the past year, Serbia has helped to identify only one mass grave in Sotin in eastern Slavonia. A great part of our cultural property taken from churches, museums and galleries is still missing. Mr. President, in 2008, this court decided, subject to one point on which the jurisdictional issues were joined to the merits, that it had jurisdiction to hear this case. In its judgment, the court decided that Serbia was legally bound by the Genocide Convention. The court's solitary caveat was in relation to a preliminary objection ratione temporis. The key date appears to be the 27th of April 1992, which is the date on which Serbia now claims it came into existence as a state. Croatia will show that the Genocide Convention is applicable from the beginning of the conflict on the territory of Croatia, and that Serbia is to be held accountable for actions taken at all material times, not only actions of the Serbian authorities, but also those of the former governing authority for which Serbia is internationally responsible. It is our case, and we will demonstrate that Serbia took over de facto and de jure control of former federal organs, including the Yugoslav People Army, the JNA, from the time the former state effectively ceased to exist. Mr. President, Croatia is well aware of the judgment of the court in the proceedings brought by Bosnia and Herzegovina against the same respondent, Serbia. In that case, too, the court had to hear about the extreme human sufferings, killings and torture. In its judgment in 2007, the court decided that the only event amounting to the crime of genocide was the massacre in Srebrenica. Croatia will adopt the approach taken by the court and show that genocide and genocidal intent is not a numbers game. The 1948 Convention aimed at preventing and outlawing actions of the kind that were taken on the territory of Croatia. Beginning in the summer of 1990, it started with unrest and instability in the areas where the Serbs lived, but grew gradually to the genocidal campaign incited, organized, controlled and facilitated by the respondent. Mr. President, in the next few days we will show you that the crimes that took place in the campaign against Croats amount to genocide within the meaning of Article 2 of the Convention and the true intention of its drafters. Let us be reminded that the intent to achieve the total destruction of the targeted group has never been seen as part of the definition of that crime. This court rightly said that genocide may be found to have been committed where the intent is to destroy the group within a geographically limited area. Respectfully, Croatia will show how crimes that took place in regions of Croatia that were designed to be, that were designated by the Serbian leadership as falling within the compass of an ethnically homogeneous Greater Serbia. Mr. President, allow me now to outline for the court the manner in which Croatia will proceed with its oral pleadings over the course of this week. We will follow the written pleadings without, however, repeating the arguments unnecessarily. We will rely on the material contained in our written pleadings, but we will also make use of new, relevant material that has come into the public domain since we submitted our memorial and reply. We will make use of updated information on deaths and missing persons, having regard to the mass graves that have been found over the past 15 years. These express the truth about what happened, events that remain open. Before turning to the outline of Croatia's oral pleadings, there is one administrative matter that I wish to address. In order to assist the court, we have prepared judges' folders, which will be referred to by counsel as appropriate. The folder contains selected legal and factual authorities and selected slides from those that will be presented during the speeches. The slides that depict written quotations are not reproduced in the folder, as the relevant passages will appear in the contrandu. The documents and slides in the folders are separated by dividers, and Croatia will provide the relevant parts of the folder prior to each session so that it is regularly updated. So, today, my colleague, Mrs. Andrea Metelko-Zgombic, will take the court through the process of dissolution of the former Yugoslavia, but since the court has heard the story on more than one occasion, Mrs. Metelko-Zgombic will focus on the most important aspects of those matters for the purpose of this case. It allows an understanding of the legal and factual relations between the former republics and the federal structure of the former Yugoslavia. She will be followed by Ms. Helen Law, who will show how the rise of Serbian nationalism affected the relations between various nations in the former Yugoslavia and brought Slobodan Milosevic to power, first in Serbia and then in Yugoslavia. She will set out how Serbian nationalism gave rise to the genocidal acts that followed, as the former Yugoslavia was torn apart. The idea of a greater Serbia had been initiated in 1986, and in 1990, Mr. Milosevic and his allies, men like Šešelj and Arkan, of whom you will hear more, started to work on its realization by the harnessing of a genocidal intent. Hate speech was used to target Croats, and this opened the door to genocidal acts. The first day of these proceedings will continue with Professor James Crawford, who will address the role of the JNA and paramilitary groups in the genocidal actions. He will show how the JNA turned from a force that protected Yugoslavia from foreign enemies into a supporter and collaborator of Mr. Milosevic's genocidal intentions. This was reflected in the command structure and in the field. The JNA rounded up volunteers and paramilitary groups from Serbia, from Croatia and Bosnia, with the intention of destroying a part of the Croat population. The JNA kept the command over them and provided artillery, aviation and any other kind of support in destroying, seizing and occupying Croatian towns and villages. We will end today with Professor Sands, who will address the Genocide Convention, taking you through its origins and evolution. He will set out elements of the actus reus and specific intent that are to be applied by the court. He will complete his presentation tomorrow morning. Then Sir Keir Starmer will then address issues of evidence and proof in these proceedings. He will explain the applicant's position with respect to the court's findings in Bosnia, in the Bosnia case, and the case law of the ICTY. Finally, on the same day, the court will be presented with evidence of genocidal activities by the respondent that took place in Croatia and its different regions. My colleague, Ms. Jana Špero, will address these issues in overview, and Professor Sands will then provide the court with an overview of how the respondent's genocidal campaign unfolded across Croatia as a whole. On the same day, in the afternoon, you will hear some first-hand accounts of the atrocities and the sufferings in Vukovar from the witness, Mr. Frano Kožul. In the same session, you will also hear our expert witness, Ms. Sonja Biserko, an individual of impeccable independence and integrity. She will set out the political and historical framework for the genocide committed against the Croat population. On Wednesday, Mrs. Blini Nigroli will address the systematic pattern of attack adopted by the Serb forces, led by the JNA, and then as they pursued their genocidal campaign. She will focus in particular on the region of Eastern Slavonia. She will be followed by Sir Keir Starmer, who will describe how this pattern of attack was put into play against Vukovar, which is amongst the worst of the crimes committed by the JNA and its paramilitary allies. The events of November 1991 are well known, but they lie at the heart of this case, emblematic of genocidal intent and act. By way of example, my colleague Professor Maja Seršić will illustrate some of the worst examples of genocidal acts in two places in Lika and Dalmatia. We will conclude the morning session of day 3 with Professor Davorin Lapaš, who will present evidence of massacres and mass killings committed with intent to destroy the Croat population. On the same day in the afternoon, you will hear a witness, Ms. Marija Katic, who will tell you about killings and destruction in the village of Bogdanovci in eastern Slavonia. The next witness will be then Mr. Ivan Grujic, an expert witness who has been personally in charge of the excavations of mass graves and identifications of the dead from the beginning of the war in Croatia. He is the person well respected for his work by the International Committee of the Red Cross, and he has testified before the ICTY on several occasions. On Thursday morning, Mr. President, I will set out Croatia's position as to the fulfillment of the actus reus element of genocide in accordance with Article 2 of the Genocide Convention by giving you evidence about the ill treatment of the Croat population, including rape and torture on attacked territories. Professor James Crawford will then address the issue of attribution. Contrary to Serbia's assertion, all the acts of genocide are, in fact, attributable to the respondent in accordance with international law. These acts were either committed directly by the JNA or under their command. It is the applicant's argument that the JNA was a de facto and de jure organ of the respondent, and as such all responsibility is attributable to it. The final presentation of the morning will be the first part of Sir Keir Starmer's argument about the legal basis for responsibility of the Federal Republic of Yugoslavia or Serbia for violations of the Genocide Convention. Mr. President, members of the Court, Friday, our final day of the first round, will be dedicated to the continued argument by Sir Keir Starmer about the legal basis for responsibility of FRY or Serbia for violations of the Genocide Convention. And after that, Professor James Crawford will address the single jurisdictional issue that remains outstanding. On the basis of the facts, it will be evident that the Court has jurisdiction over the entire period of these unhappy events. And finally, Professor Sands will bring together the main strands of Croatia's case and bring our arguments to conclusion. Mr. President, members of the Court, Croatia will not address the issues raised by Serbia's counterclaim in this first round. In accordance with the schedule set by the Court, these will be addressed on the morning of the 18th of March. Mr. President, that sets out the approach that will be taken by Croatia over the next week. We appreciate that the Court may wonder why it has taken so long to get to this stage. Indeed, why the parties have not been able to resolve their differences. We have tried time and again. Yet, time and again, new governments have come into power in Serbia who were unwilling to confront the truth about the events that began more than 2 decades ago. For this reason, they are not mere historical facts and historical events. They continue to resonate, and the Court continues to have an important role in addressing the facts and confirming once for all that the requirements of the 1948 Convention have been met in relation to Croatian application. And now, Mr. President, I invite you to call Ms. Metelko-Zgombic to the bar. Thank you.
I thank Professor Sanjic-Grotic for her agent's introductory statement, and I now call on Ambassador Metelko-Zgombic, co-agent of Croatia, to continue the presentation of its case. You have the floor, madam.
Mr. President, members of the Court, it is my honor and privilege to appear before you once again on behalf of the Republic of Croatia. I will address the historical and political context of the dissolution of the SFRY, and by doing this, I will respond to the unfounded claim by the respondent that it can have had no responsibility for conduct before its former proclamation on 27th of April 1992. Serbia asserts that before 27th of April 1992, the only state with responsibility for any relevant acts or omissions in Croatia was the Socialist Federal Republic of Yugoslavia, the SFRY. This is a strategy of evasion, and it is not the one that the Court should accept. The reality is that during the critical period in 1991, the institutions of the SFRY had been appropriated by an emergent Serbian state and were no longer functioning as a federal organs in accordance with the 1974 constitution of the former Yugoslavia. Note that when Serbia, together with Montenegro, adopted the new constitution on 27 of April 1992 and named the state the Federal Republic of Yugoslavia, it did not ask for recognition by the international community, and it did not consider itself to be a new state, different from the SFRY. The international community did not accept its claim of continuity, neither did Croatia, but the claim did implicitly, even expressly, involve an avowal by the Federal Republic of Yugoslavia of the conduct of the organs, previously organs of the SFRY, which it had taken over in the process of dissolution of the former Yugoslavia. In short, the Federal Republic of Yugoslavia continued to operate with the organs over which it assumed control in the process of dissolution of Yugoslavia. For convenience, I and my colleagues will simply refer to the Federal Republic of Yugoslavia by the current name, Serbia. In this presentation, I'm going to outline the process of the dissolution of the SFRY. To put these events in the context, some knowledge of the historic and political background is necessary and is provided in the pleadings, in particular in Chapter 2 of the memorial and in Chapter 3 of the reply. I will focus on the structure of the SFRY and on the developments which caused the constitutional crisis in the 1980s and early 1990s, and which ultimately led to the SFRY's dissolution during the course of 1991. These events took place in the context of a re-emergence of the extreme Serbian nationalism and the adoption of the Serbian leadership of a plan for a de facto Greater Serbia. I can do so briefly because the facts are relatively well known to the court, is familiar with them from the other cases. My colleagues will return to particular episodes of that process as required for the presentation of the case, and on Thursday, Professor Crawford will deal with the legal implications for the attribution of conduct. Mr. President, members of the court, let me briefly set the scene geographically. On the scene, you can see various geographical regions of Croatia. In these proceedings, particular reference will be made to Banovina, Kordun, Lika, Dalmatia, and for the purpose of these proceedings, Eastern and Western Slavonia. It is mainly in these regions that the acts that are subject to this application were committed. Acts that, as you will hear during the course of this week, amounted to the genocide. You can now see on the screen a map of the whole territory of the former Yugoslavia. The SFRY was a federal state with 8 constituent units. Its 6 republics were Bosnia and Herzegovina, Croatia, Macedonia, Montenegro, Serbia, and Slovenia. It had also 2 autonomous provinces, Kosovo and Vojvodina, which were part of the Federation and also part of Serbia. It is essential for this case to understand the fundamental principles on which the SFRY was established and on which it functioned. Without this understanding, it is impossible to fully appreciate the developments in the SFRY, including key events that led to the destruction of its federal institutions and its ultimate dissolution. Established on the principle of the self-determination of peoples, the Second Yugoslavia was from its inception envisaged as a federation of 6 constitutionally equal republics. This was in a sharp contrast to the previous First Yugoslavia, which existed between the 2 world wars and which was a Serbian-dominated unitary state, often referred to as the dungeons of nations. The principles of federalism and equality of the constituent republics were implemented in the first post-war constitution of Yugoslavia in 1946 and were further developed and reinforced in 1974 constitution, which was in force until the dissolution of the SFRY. Under the 1974 constitution, the sovereignty of the 6 constituent republics and the 2 autonomous provinces were enhanced. The result was a federation with distinct confederal elements. This considerably strengthened the position of the republics in relation to the federal structure of the SFRY. All matters that were not explicitly granted to the federal government by the federal constitution were reserved for the republics and the autonomous provinces. The central organ of the federation was the collective rotating presidency, composed of a member from each of the 6 republics and 2 autonomous provinces. Decisions were taken on the basis of a majority of the 8 votes of the members of the presidency, who were elected for the terms of 5 years. As provided under Article 327, the presidency of the SFRY was required to rotate the position of the president and vice president from among its members for a term of 1 year. Under Article 313 of the SFRY Constitution, the presidency of the SFRY was, I quote, "the supreme body in charge of the administration and command of the armed forces in war and peace," unquote. Under Article 328, the president of the SFRY presidency was in charge of the command of the armed forces and was also the chairman of the Council for the National Defense. Mr. President, soon after the death of Tito in 1980, the Socialist Republic of Serbia began to question the basic principles governing the structure of the SFRY. With the re-emergence of extreme Serbian nationalism, inflamed by the infamous 1986 memorandum of the Serbian Academy of Science and Art, the so-called SANU memorandum, and Milosevic's coming to power in 1987, Serbia took a series of unilateral actions which disrupted the balance between the republics and cut deeply into the core structure of the federal state. A key development in the undermining of the constitutional system of the SFRY was the adoption on 28th of March 1989 of an act amending the Serbian constitution, followed by the Serbian constitution in 1990. In contravention of the constitution of the SFRY, the act abolished the autonomy of the 2 autonomous provinces. Power was centralized in the Republic of Serbia. Serbia retained, however, their representatives in federal organs. As a result of these changes in Kosovo and Vojvodina, along with the establishment of a pro-Serbian government in the Montenegro, Serbia came to control 4 out of the 8 votes in the presidency of the SFRY. This development came to be seen as marking the beginning of the constitutional crisis in the SFRY. It became increasingly clear to the non-Serbian members of the SFRY presidency that they could have exercised no real power and authority in this federal organ, and that half of the members of the presidency had effectively been taken over by Serbia. In March 1991, the SFRY presidency rejected the Serbian proposal to declare a state of emergency. Responding to the failure to get the measures to the presidency, Serbian President Slobodan Milosevic made a televised speech noting that the refusal of the other republics to declare the state of emergency, I quote, had pushed Yugoslavia into the final stage of its agony, unquote. In this speech, made on 17th of March 1991, several months before the conflict started, Milosevic declared, I quote, "Under the existing conditions, the Republic of Serbia does not recognize the legitimacy of the federal presidency," unquote. On 15th of May 1991, the presidency, dominated by Serbia, with 4 votes against it, refused to recognize the constitutionally prescribed accession of the Croatian representative, Stjepan Mesic, to the office of the president of the SFRY presidency. By that date, In mid-1991, the Yugoslav People's Army, or the GNA, no longer functioned as a federal organ. Command and control over the army had clearly vested in the Serbian leadership and those senior military figures who gave their allegiance to Serbia. Professor Crawford will show in more detail how the constitutional crisis extended to the GNA, but I will highlight a few key events. The GNA had already disarmed the territorial defense forces in Croatia. The territorial defense forces were a component of the armed forces of the SFRY, but they were under the control of each of its constituent republics. The disarmament of the Croatian forces was planned and quickly undertaken in May 1990, before there had been a handover of the authority following the elections and before the new government had been installed. The disarmament took place on the basis of a strictly confidential command signed unlawfully and without the knowledge and agreement of the SFRY presidency by the head of the General Staff of the GNA, General Blagoje Adžić. The arms taken, an estimated 80,000 to 200,000 guns, were stored in the warehouses of the GNA. Borisav Jović, the Serbian representative of the SFRY presidency, wrote about the event on 17th May 1990. I quote, "Practically speaking, we have disarmed them. Formally, the head of the General Staff did this, but in fact, it was actually under our order. Extreme reaction by the Slovenes and Croats, but they have no recourse." Unquote. In accordance with Article 5 of the Constitution of the SFRY, the boundaries between the republics could only be altered by the mutual agreement between the republics concerned. But in January 1991, President Milosevic made it clear that Serbia would not accept the separation of the Serbian nation into different states. In March 1991, he said, I quote, "Borders, as you know, are always directed by the strong. They are never dictated by the weak." Unquote. By early 1991, then, the Serbian leadership had begun to question the territorial borders between the constituent republics. In response to an explicit question asked by Serbia about the nature of the republican borders within the SFRY, the Badinter Commission concluded that the borders between Croatia and Serbia, between Serbia and Bosnia and Herzegovina, or with other states, could be changed only by free will and a common agreement. In the absence of such an agreement, the former administrative borders of the republics had become external borders and were protected by international law. Mr. President, members of the court, in January 1991, the SFRY presidency has rejected a Serbian proposal to allow GNA intervention in Croatia. In March, as I mentioned, it had rejected another Serbian proposal to declare a state of emergency. Faced with these refusals, Serbia went ahead on its own initiative. In early April 1991, Milosevic and Jović met the generals Kadijević and Adžić. The generals assured Serbian leadership that the GNA would secure areas held by rebel Serbs in Croatia without consulting the presidency. On 5th July 1991, Milosevic and Jović, who was at the time a Serbian representative in the SFRY presidency, issued General Kadijević a series of demands, which he accepted. They demanded that the GNA concentrate its main forces along a line that would give it control over all the territory where Serbs lived. They also demanded the complete elimination of Croats and Slovenes from the GNA. It is plain that by the middle of 1991, and despite the continuation of formal and obvious futile meetings, the SFRY presidency had been effectively rendered impotent by Serbia. This set the stage for what followed. In September and October 1991, the GNA and Serb paramilitary units began a general attack on all fronts in Croatia. On 7th of October 1991, the historic building in the Croatian government in the center of Zagreb was attacked from the air. This deliberate attack occurred while the Croatian president, Franjo Tužman, the then president of the presidency of the SFRY, Stjepan Mesić, and the SFRY prime minister, Ante Marković, were meeting inside the building. It was in this violent context that next day, on 8th of October 1991, the Parliament of the Republic of Croatia declared the independence of Croatia. Mr. President, members of the court, can there be any stronger proof of the collapse of the former common state and its organs, and of Serbian control of the GNA, than the fact that the GNA attempted to kill the head of state and head of government of the SFRY, together with the President of Croatia? The Badinter Commission concluded in its opinion number 1 of 29th of November 1991 that by that time the SFRY was already in the process of dissolution. In truth, that process was by then advanced and in fact irretrievable. In its response to these facts, Serbia points to international and diplomatic activities undertaken by the SFRY between 1991 and 1992. These activities included the conclusion of bilateral and multilateral agreements, participation in diplomatic conferences and meetings. But this level of diplomatic activity cannot mask the reality. The fundamental breakdown and the inability of the SFRY organs, in particular the collective presidency, to govern the SFRY during this period. Nor can it hide the fact that at the time, the Serbian president had publicly disavowed the legitimacy of the decision taken at the federal level. Serbia also argues that the finding of the ICTY in the Martic case, namely that Milosevic participated in a joint criminal enterprise with, among others, Generals Kadijevic and Adjic, does not mean that international responsibility for acts and omissions that took place in 1991 can be transferred to a state that only came into existence in April 1992. But the relevance of the joint criminal enterprise is that it indicates the extent to which the Federal Secretary of National Defense of the SFRY and the head of General Staff of the GNA had by April 1991 committed themselves to the creation by force of a de facto Greater Serbia. This plan came into existence no later than April 1991. It is an indispensable element of the creation by force of a Greater Serbia. An indispensable element of the creation by force of a Greater Serbia was a plan to rid large part of Croatia out of its Croatian inhabitants, including by the destruction of a part of the Croatian population. That was, in plain words, a genocidal plan. Mr. President, members of the court, I will now briefly address another important development, the rebellion of Croatian Serbs supported by Belgrade. From 1989 onwards, mass rallies of Serbs in Croatia were instigated, supported and encouraged by Belgrade. You will recall that at that time Croatia was still governed by the League of Communists. Soon after the democratic transition in Croatia in 1990, an open Serb rebellion broke out, backed by Serbia and the GNA. In August 1990, weapons were seized en masse from police stations in areas where Serb majority or significant Serb minorities. Roads and railway lines were blocked or cut off in the central area of Croatia, the Knin area. From that time, these areas were beyond the effective control of the Croatian authorities. This rebellion resulted in the self-proclaimed Serb entities on the territory of Croatia in 1990 and 1991, the so-called Serb Autonomous Provinces, or SAOs. The establishment of these entities is discussed in more length in Croatia's pleadings. The first to be proclaimed was the so-called SAO Krajina. The Serb community in Knin adopted a resolution establishing this unity one day before the proclamation of the new constitution of the Republic of Croatia on 21st of December 1991. The Serbs in the area ceased their relations with the Croatian government, and the police there separated themselves from the policing system of Croatia. On 19 December 1991, the rebel Serbs proclaimed the so-called Republic of Serbian Krajina, the RSK. The RSK was soon joined by the other two self-proclaimed SAOs in the territory of Croatia. They were the SAO Western Slavonia and the SAO Eastern Slavonia, Baranja and Western Sirmia. By the end of 1991, almost one-third of Croatia's territory was occupied, with a genocidal campaign underway. Mr. President, members of the court, just to complete the story, after more than 4 years of occupation, destruction of Croats, failed negotiations, facing constant destruction of its towns and infrastructure, the intransigency of the rebel Serbs, and the inefficiency of the UN, Croatia regained control over most of its occupied territory in 1995. The last area to be reintegrated into Croatia was that of Eastern Slavonia, including the area around Vukovar, where some of the worst atrocities of the genocide were committed. The area was peacefully reintegrated by January 1998. Mr. President, members of the court, you do not need to dwell on any of these facts at great length. The evidence is plain and overwhelming that by early 1991, the SFRY had in reality ceased to exist and function as an effective federal state. Within a few months, by the middle of 1991, as the conflict in Croatia began, it was also plain that Serbia, under the leadership of Milosevic, had rendered the presidency effectively impotent and had taken control of the GNA. Serbia, including the GNA, was pursuing an expansionist and aggressive policy of acquiring the part of Croatia that is envisaged as forming part of a greater Serbia. This policy included support for the self-proclaimed Serb entities that were established on the Croatian territory in 1991. This was the context for the genocidal campaign that ensued. With your permission, Mr. President, Ms. Law will begin the process of analyzing that genocidal campaign by setting out in more detail the influence of the extremist Serbian nationalism in the period before conflict. Thank you, Mr. President, members of the court, for your attention.
Thank you very much, Madam Co-Agent. And I now give the floor to Ms. Helen Law. You have the floor.
Mr. President, members of the court, it is an honor for me to appear before you in these proceedings on behalf of the Republic of Croatia. I anticipate my presentation taking approximately 30 minutes. With your permission, I will continue without a break, but of course please do indicate if at any stage you would like me to break. My presentation is the second of the 3 presentations this morning addressing the background of the genocide committed by Serbia against ethnic Croats. It focuses on the rise of extremist Serb nationalism in the years leading up to the genocide. Professor Crawford will then describe the parallel Serbianization of the Yugoslav People's Army, the JNA, that contributed to the acts of genocide. This morning I will address three matters. First, the rise of extremist Serbian nationalism from the late 1980s and the virulent campaign of hate speech against Croats conducted in the Serbian media. Second, the support shown by President Milosevic for extremist nationalist aims. And third, the connection between extremist Serbian nationalist ideology and the genocidal acts committed in Croatia. I begin then with the rise of extremist Serbian nationalism in the period before the conflict in Croatia. This builds on the accounts of the rise of extremist Serbian nationalism following the death of President Tito in 1980, set out in our pleadings. The political importance of Serbian nationalism in this period does not appear to be in dispute between the parties. Serbia admits that prior to 2000, Serbian nationalism was the leading political idea. It does not dispute that hate speech was abundant in the Serbian media at the end of the 1980s and during the 1990s. Indeed, the respondent goes so far as to concede the role played by historical revisionism during this period and admits that Serbian nationalists misused the recollections of these past events. The respondent's assertions that Serbian nationalism went hand in hand with Croatian nationalism have been refuted comprehensively in Croatia's pleadings. The role and effect of Serbian nationalist propaganda was confirmed by the expert report of Professor de la Brosse, a senior lecturer at the University of Reims, which was submitted to the ICTY trial chamber during the proceedings against Slobodan Milosevic. In 2004, the trial chamber adopted the conclusions of the report, noting that, and as you should see on the screens, Professor de la Brosse determined that a comparison between Serbian, Croatian, and Bosnian nationalist propaganda yielded the conclusion that Serbian propaganda surpassed the other two, both in the scale and content of the media messages put out. The publication in 1986 of a memorandum drawn up by the Serbian Academy of Sciences and Arts, which you've heard referred to as the SANU Memorandum, precipitated a period in which extreme nationalist propaganda dominated Serbian culture. The memorandum was, in effect, a manifesto setting forth a Serb nationalist reinterpretation of the recent history of the SFRY. It carried weight because of the authority of its authors and reflected basic precepts of the Serb nationalist movement. It was premised on the view that the Socialist Republic of Serbia and the Serbs in the other republics of the SFRY were in a uniquely unfavourable position within the SFRY. The memorandum adopted the position that the Serbian nation is now the only nation in Yugoslavia without its own state. The memorandum proposed a review of the SFRY constitution, under which the autonomous provinces would become an integral part of Serbia and the federal state would be strengthened. This option, referred to in the SFRY as the Unitarian option, was unlikely to be acceptable to other republics in the SFRY, fearing the domination of Serbian interests in a Unitarian state. The memorandum also claimed that a covert programme for the Croatization of ethnic Serbs was underway in Croatia. In her expert report submitted to the ICTY during the trial of Slobodan Milosevic, Professor Audrey Budding, an associate at the Harvard Academy for International and Area Studies, who wrote her doctoral dissertation on Serb intellectuals and the national question, described the memorandum as the best-known document of the contemporary Serbian national movement, and explained how it set off a political firestorm. As she noted, the second half of the memorandum asserted that the very survival of Serbs in Croatia was threatened by assimilation. Serbs in Croatia were never as endangered in the past as they are today. She concluded that the memorandum was inflammatory because of the contrast between its complaints about the position of Serbia and Serbs within Yugoslavia, and its vague and elliptical references to a possible post-Yugoslav future. The respondent claims that Croatia exaggerates the importance of the Sanu Memorandum. We disagree, and so does the ICTY, having regard to the reliance placed on the reports of Professor Budding and Professor de la Brosse. Professor de la Brosse found that it was the deliberate leaks of the Sanu Memorandum that sparked things off and raised the issue of Serbian nationalism publicly. Other independent commentators have described the memorandum as a political bombshell, one that convulsed the country. Following the publication of the Sanu Memorandum, articles began to appear in the Serbian media that demonized the Croats, referring to their alleged genocidal tendencies. As noted in the written pleadings, during the Second World War, terrible crimes were committed against the Serbs and others by the Ustasha puppet regime of the so-called independent state of Croatia, the NDH. From the early 1980s, leading Serbian newspapers ran inflammatory articles about the Ustasha concentration camps in Jasenovac. A number of Serbian historians and journalists gave vent to the theory that the Croatian people were collectively to blame for the large number of Serbs who were killed between 1941 and 1945. This promoted a view that Croats were, by their very nature, genocidal in character, and that they adhered to a continuing genocidal intent against the Serbs. As Professor de la Brosse's report notes, and you see on the screen, the incessant reminders of the NDH and atrocities committed by the Ustasha were an alibi for the political objectives of the Serbian regime, and were at the root of the development and strengthening of inter-ethnic hatred. The parallel between the past and the present, comparing Franjo Tuđman's regime to that of Ante Pavelić, was made to raise anti-Croatian hatred to fever pitch. The report sets out several examples in this regard. In 1986, a mobile exhibition entitled "The Dead Open the Eyes to the Living" was displayed at JNA barracks throughout Yugoslavia. The exhibition, which was open to the public, ran from 1986 to 1991. From the map showing the exhibition site, it is easy to see that these were the areas where genocidal acts were later perpetrated by the respondent. This had a clear goal. It connected the crimes of World War II to the allegedly separatist tendencies in the Socialist Republic of Croatia. This coincided with articles that appeared in weekly journals with a large JNA readership, for example, Front and People's Army, fomenting the demonization of the Croats. These and other actions played a key role in preparing the ground for the acts of genocide against Croats that were to follow. In April 1991, a member of the Serbian parliament, Milan Peroški, made a well-publicized and widely reported speech in the village of Jagodnjak in Baranja, northeastern Croatia. Referring to Croats and Hungarians, he declared that this was a Serbian land, and then said, as you can see on your screens, Whoever tells you that this is his land is an usurper, and you have the right to kill him like a dog. Vranje was occupied by Serb forces in August 1991 and remained under Serb control until 1998. It was the scene of many horrific atrocities. I turn to my second point, namely the role played by Slobodan Milosevic in whipping up anti-Croat hatred. The ICTY found in Martić that Milosevic and others, including Babic, Adzic, Karadzic, Mladic and Vojislav Šešelj, were party to a joint criminal enterprise, a JCE. Its common purpose was the establishment of an ethnically pure Serb territory. The finding withstood the subsequent 2008 appeal. I will now examine Milosevic's role in supporting and encouraging extremist Serb nationalist aims in the period leading up to the genocide. According to Budding, from 1990, the Serbian leadership actively supported Serb nationalists in Croatia in order to secure their allegiance to Belgrade and against the newly elected Croatian government. By August 1990, Serbs in the area around Knin in Croatia severed relations with Zagreb and were engaged in an outright rebellion by cutting off the Knin area from the rest of Croatia, in a move that came to be known as the Log Revolution. At this time, President Milosevic used hate speech against the Croats to rally support for his nationalist aims. As noted in the 1994 report of the UN Commission of Experts, in addressing Serbia's parliament in 1991, he said, and again you see on the screens, "Serbia and the Serbian people are faced with one of the greatest evils of their history, the challenge of disunity and internal conflict. All who love Serbia dare not ignore this fact, especially at a time when we are confronted by the vampiroid, fascistoid faces of the Ustashas, Albanian secessionists and all other forces in the anti-Serbian coalition which threaten the people's rights and freedoms." He also made use of the media to legitimize the goal of a greater Serbia, including through violent means. As Professor de la Brosse noted in his authoritative report, and you see on the screen, the political and military goal of a state for all the Serbs, which presupposed annexing Bosnian and Croatian territory in which Serbs lived, was supported by the Serbian media that served as tools to legitimize the use of force and violence. In July 1991, Slobodan Milosevic would again choose Serbian television to deliver a speech in which he announced that war had become inevitable. The rise of Serb nationalism also found expression in the formation of extremist political parties and paramilitary organizations. The Serbian leadership and the JNA worked in close concert with extremist politicians such as Vojislav Šešelj and Arkan, and the paramilitary organizations they established, as well as many others. The link between President Milosevic and extremist Serbian nationalist views has been confirmed by the ICTY. In its 2004 Milosevic decision, the ICTY trial chamber adopted the testimony of US Ambassador Galbraith to the effect that Slobodan Milosevic was the architect of a policy of creating Greater Serbia, and that little happened without his knowledge and involvement. This applied equally to the situation in Croatia. One of the most prominent extreme nationalist politicians during this period was Vojislav Šešelj, who established the Serbian Radical Party, the SRS, in Serbia in 1991. He is currently on trial for war crimes before the ICTY. As outlined in the memorial, Šešelj began his rise in the Serbian political arena in 1990. In June 1991, he was elected to the Serbian Assembly. He and his paramilitary organization, Šešelj's Men, were responsible for countless genocidal atrocities across Croatia, including in Vukovar. As set out in the pleadings, Šešelj advocated an extremist plan to achieve a greater Serbia, a plan which was aired on Serbian state-controlled television. When asked where the Serbian borders should lie, Šešelj stated, "The western border is the Karlobag, Ogulin, Karlovac, Virovitica line. There can be no changes unless a new war takes place. You can see that the Croats don't have much territory left." You can now see on your screens a video.
Kako mislite bi trebali budu granice, odnosno gdje da budu granice Srbije?
Na liniji Karlobag, Ogulin, Karlovac, Virovitica, to su zapadne srpske granice, a što se tiče severnih, istočnih i južnih, oni su davno međunarodno-pravnim aktima regulisane i tu više nikakvih promjena ne može da bude bez nekog eventualnog novog rata. Ovo je Karlobag, Ogulin, Karlovac, Virovitica. I ovo plavo, to su teritorije naseljene srpskim narodom, tamo gdje je srpski narod u većini. A vidite koliko Hrvatima onda ostaje njihove zemlje. Ne mnogo.
A related photograph is in your judge's folder at tab 4. And Šešelj's vision has been set out in the memorial. Serbia has accepted that Šešelj became President Milosevic's ally by November 1991. Mr. Milosevic relied on Šešelj's extremist rhetoric at a much earlier stage, well before the conflict began. Although Milosevic and Šešelj later fell out, Milosevic ensured that Šešelj was in a position to promote his extremist nationalist aims. This was clear from the uncritical prime-time coverage that Šešelj received on the Milosevic-controlled state-run television, as confirmed by Professor de la Brosse in his expert report. As you see on the screens, systematic media coverage was given to Vojislav Šešelj's positions, such as the declaration he made in September 1991 before the Serbian parliament, which was broadcast by Belgrade television. Karlobag, Ogulin, Karlovac, Virovitica must be our option, and the army must withdraw its troops to this line. If they cannot be withdrawn from Zagreb without a fight, they should pull out under fire and constantly shell Zagreb. The army still has unused resources. If its troops are in danger, it has the right to use napalm bombs and everything else it has in its arsenals. They wanted war, and now they have it. Šešelj was one of those responsible for the validation of the Chetnik movement. The Chetnik movement was based on an extreme form of nationalism which centered on the idea of a greater Serbia. In the implementation of their nationalist aims, the Chetniks collaborated with the Italians and the Germans during the Second World War and committed atrocities against Muslim and Croat populations in parts of Bosnia and Herzegovina and Croatia. Before breaking away to establish the SRS, Šešelj had co-founded the extremist nationalist Serbian Renewal Party the SPO, in 1989 with Vuk Draskovic, a writer and later a politician, who sought to resurrect the reputation of the Chetniks. He was a vocal proponent of the need to establish a Serbian Krajina region in Croatia. As pointed out by Professor Budding in her report, the SPO was the most prominent party in putting forward specific border claims for a Greater Serbia in the 1990 Serbian elections. The evidence shows, and it is not seriously disputed, that President Milosevic, 1, made use of Šešel's rhetoric and extremist ideology in the build-up to the war in Croatia, in particular by ensuring his access to the state-controlled media, and 2, that the Serbian leadership was then also prepared to give his paramilitary organization a key role in the conflict, during which they were involved in the commission of crimes. In Croatia's case, genocidal crimes. Another prominent extremist Serb nationalist who played an important part in the conflict was Željko Ražnjatović, known as Arkan. As explained in the pleadings, Arkan's paramilitary organization, the Serbian Volunteer Guard, which was later referred to as the Tigers, was established on the 11th of October 1990 and had its headquarters in Erdut in eastern Slavonia in Croatia. This followed a decision of the Federal Secretariat for National Defense to form special units for the protection of the Serbian leadership and Serbia itself. These units reported directly to the headquarters of the JNA, and Arkan was appointed by the then Secretary of the Federal Secretariat for National Defense, Lieutenant Colonel General Marko Negovanovic. As shown in the pleadings, Arkan used hate speech against the Croats, whom he consistently referred to as Ustašas. He and his paramilitary group, Arkan's Tigers, were also responsible for some of the worst atrocities of the genocide. Arkan and his paramilitary organization were deployed in eastern Slavonia, where they committed acts of genocide in and around Vukovar in the summer and autumn of 1991. There is overwhelming evidence of Arkan's ties with the governments of Serbia and the FRY, with the self-declared Serbian republics, and with the JNA. Serbia acknowledges in the rejoinder that Arkan had political connections with the leadership of Serbia. Serbia conceded this, although it claims that the nature and the extent of these connections are not easy to determine. In fact, there is clear evidence of the nature and extent of these connections, as set out in the pleadings and in the findings of the ICTY, to which my colleagues will refer. Šešel and President Milosevic were committed to what came to be known as the amputation of Croatia. According to this idea, up to 1/3 of the territory of the Republic of Croatia would be cut away from the boundaries and included within an extended Serbian state. The core of the amputation consisted of those parts of Croatia in which Serbs claimed they were in the majority or a significant minority. But the amputation was also to include larger Croat majority towns, such as Dubrovnik, Split, Zadar, Šibenik, and Osijek, in which there were relatively few Serbs. The amputation was coupled with an intention to destroy a part of the Croat population. The original core of 11 districts with a Serbian ethnic majority gradually grew due to the further addition of smaller Serb enclaves, but also of areas where the Serbs had never been even a significant minority. A map published on the 1st of March 1991 in the Serbian weekly paper NIN provided the clearest possible indication of the Serbian intent to extend its territorial limits into the Republic of Croatia. In March 1991, Milosevic confirmed the Serbian government's support for the nationalist Serbs in Croatia. You should see on your screens. I have asked the Serbian government to carry out all preparations for the formation of additional forces whose volume and strength would guarantee the protection of the interests of Serbia and the Serbian people. The citizens of Serbia can be sure that the Republic of Serbia is capable of ensuring the protection of its own interests and those of all its citizens and the entire Serbian population. The Republic of Serbia, the citizens of Serbia, and the Serbian people will resist any act of dismantling our homeland. Serbia now accepts that the leadership of the Republic of Serbia, headed by Slobodan Milosevic, supported the establishment of Serb territorial autonomy in Croatia. It did so publicly and covertly, and provided considerable political and financial support. Serbia argues that there is a missing connection between Croatia's evidence as to the rise of Serbian nationalism and the establishment of genocidal intent. There is no missing connection. The connection between extremist Serbian nationalist ideology and the Serbian leadership's openly expressed plan to create a greater Serbia, involving the destruction of a part of the Croat population, is well documented in the evidence before the court. And so is the connection between that ideology and the conduct of the campaign itself. In particular, through the participation of extremist paramilitary organizations. This is clear from the following points. Extremist Serbian paramilitary organizations played a direct role in the genocide. Paramilitaries began to be integrated into the JNA from around September 1991, following a refusal on the part of conscripts and reservists from Croatia, Slovenia and other republics to join the JNA. To meet the significant shortfall in numbers required for the campaign, the JNA enlisted tens of thousands of volunteers. The Army Command and senior officials from the Serbian Ministry of the Interior also worked closely with leaders of paramilitary forces, while not formally integrated into the JNA, worked in concert with it and operated under JNA command. Prominent extremist Serbian nationalist politicians, including Šešelj and Arkan, formed paramilitary groups which actively participated alongside the JNA in the acts of genocide perpetrated in Croatia. The Serbian leadership, led by Slobodan Milosevic, encouraged support for the views of extremist nationalists by promoting their access to the media and supporting their aim to create a greater Serbia. From the late 1980s onwards, extremist commentators and politicians openly engaged in hate speech against Croats, who were systematically demonized as Ustaša or fascists, said to be collectively responsible for the crimes of the puppet NDH regime during World War II. The view that Serbs were under imminent threat from Croats was widely promoted. The idea that a single, ethnically pure state for all Serbs a Greater Serbia, had to be created by force, therefore took place in this toxic environment. The clear implication was that the Croat population of such territory would have to be destroyed. In this way, the emergence in the 1980s of a plan for a single state for all Serbs, a de facto Greater Serbia, was not merely a territorial reconfiguration of the SFRY to be achieved by conventional armed conflicts. It became inextricably linked with extremist views about Croats and the intention to destroy a part of the Croat population. These views promoted the idea that it was impossible for Croats and Serbs to live together peacefully, as the Croats posed a threat to Serbs by their very presence in the territory to which Serbia now laid claim. This was the context for the establishment of a Greater Serbia, based on the forcible acquisition of approximately 1/3 of the territory of Croatia. That plan underpinned a genocidal campaign. In this way, expressions of extremist Serbian nationalist ideology played a key role both before and during the genocidal conflict in Croatia. The demonization of the Croats was the first stage of a program that led to their intended destruction. During the conflict, proponents of this extremist ideology participated in political and military actions during the genocidal campaign in Croatia, both within the ranks of the JNA and alongside it, as Professor Crawford will later explain. Mr. President, members of the Court, I thank you for your kind attention.
Thank you, Ms. Lowe, for your presentation. And Professor Crawford will address the Court after the break. This sitting is adjourned for 15 minutes. Please be seated. The hearing is resumed, and I invite Professor Crawford to address the court. You have the floor, sir.
Thank you, Mr. President. Mr. President, members of the court, it is again an honour to appear before you on behalf of Croatia. Serbia has sought to distance itself from the conduct of the JNA, and it's obvious why Serbia would try. The evidence for the JNA's role in what we say were acts of genocide, which role has been the subject of numerous findings of the ICTY, is overwhelming and in many cases beyond dispute. From early to mid-1991, the JNA purported to adopt a neutral buffer zone policy, but in fact it intervened to ensure that rebel Serbs could seize control of Croatian territory. From August 1991, it was involved in some of the worst atrocities, directly and through collusion with Serb paramilitaries. Among other examples, after the fall of Vukovar in eastern Slavonia, high-ranking JNA officers aided and abetted the large-scale murder and torture of prisoners. Faced with these facts, Serbia falls back on the formalistic argument that until 27 April 1992, the JNA was a de jure organ of the SFRY and not an entity for which Serbia had responsibility. That claim partly involves issues of law, which I will address on Thursday. It also raises an issue of jurisdiction, which I will address on Friday. But above all, it involves questions of fact. And as to the facts, the evidence is clear. By July 1991, before the conflict began, the SFRY had ceased to function as a state. Instead, the JNA was following the political direction of the Serbian leadership and was engaged in an aggressive campaign to seize some one-third of Croatia's territory. In this presentation, I will address three aspects of the developing role of the JNA. First, the process of what we have termed Serbianization, which brought the JNA firmly under the control of the Serbian leadership. Second, the phony policy of neutrality. Third, the JNA's role in arming and then controlling and directing Serb forces in Croatia. This narrative about the JNA not only provides crucial background to the facts of what occurred, it underlies their legal consequences, including the attribution to Serbia of the acts of the JNA. I'll finish this presentation with a word about the mismatch between Serbian and Croatian forces. Mr. President, members of the Court, Croatia has presented a substantial body of evidence on the critical role of the JNA in the atrocities committed in Croatia. This includes JNA orders and regulations, witness testimony, press articles from the official JNA newspaper Narodnija Armija and elsewhere, and videotapes. It also includes extracts from memoirs by members of the Serbian political and military leadership, in particular Borisav Jovic, at the time a Serbian representative in the SFRY presidency, and General Kadijevic, the SFRY defence minister. Croatia will also refer the Court to a number of rulings of the ICTY that support our case on the role played by the JNA in the crimes committed during the war. These rulings lend further support to the conclusion that the JNA was pursuing Serbian aims and objectives from at least July 1991, and they established its relationship with other Serb forces. I begin with some background on the JNA. It was an important constitutional, political and social entity in the SFRY. Its role was to protect, as a whole, the interests of the 6 republics and the 2 autonomous provinces in the SFRY. Under the 1974 constitution of the SFRY, the control of defence was decentralised to a significant degree. The military structure comprised 2 elements. The first was the JNA itself. You can see on the screen how at this time the organisational structure of the JNA provided for a number of armies and independent corps whose territorial locations generally corresponded to the internal borders of the republics. As the ICTY explained in Merksic, I'm sorry, I've been practicing that, Merksic, not very well it seems. The law of the SFRY, and I quote, allowed for the possibility in time of war, or in the event of immediate threat of war or other emergencies, for the armed forces to be reinforced by volunteers. These volunteers, thousands of them from Serbia, joined the JNA of their own volition, rather than because they were subject to military service. The second element of the military structure was the Territorial Defence Forces, often referred to by the abbreviation TO, for Territorialna Obrana. These were established in each of the republics, whereas the JNA itself acted under the control of the SFRY presidency. In peacetime, the republics themselves controlled the Territorial Defence Forces. As the trial chamber explained in Merksic, they were organised on a territorial basis at the level of local communities, municipalities, autonomous provinces and republics, the highest command being the republican level. The process of Serbianisation began as early as the mid-1980s, when the JNA increasingly allied itself with Serbian conservatives who opposed political reform and favoured greater centralisation. An important shift occurred in 1988 when the JNA was restructured. In effect, it was re-centralised. You can now see on the screen a map of military regions in the SFRY. The restructuring of the JNA removed the significant powers of the territorial defence forces of the republics and made them subordinate to the military regions. Ultimately, this more centralised structure would facilitate the takeover of the JNA by the Serbian leadership. The process is well evidenced and is detailed rather thoroughly in our reply. I'll take you only to a few points. In light of the evidence, it is profoundly counterfactual to suggest, as the respondent now does, that the JNA could have continued to function as an organ of the SFRY until April 1992. You recall that Slobodan Milosevic, the President of Serbia, had announced publicly in March 1991 that Serbia no longer recognised the legitimacy of the SFRY presidency. The constitutional crisis that undermined the role of the collective SFRY presidency and led to the dissolution of the SFRY extended to the JNA. Over the period of the crisis, it progressively ceased to function as an organ protecting the interests of all of the republics and autonomous provinces. By early 1991, the SFRY had lost control. Instead, the JNA took its orders from and pursued the political objectives of the Serbian leadership. Let me quote from the 2003 report of Reynold Turnens, submitted to the ICY in the Milosevic case. Mr. Turnens is a military expert with experience as a Balkan analyst in the Belgian Ministry of Defence. He participated in UN peacekeeping operations in the former SFRY from 1994 to 1999. He said, and I quote, "From late summer 1991 onwards, orders and instructions from what remained of the SFRY presidency, the Supreme Command and the Supreme Command staff, indicated that at least de facto the JNA moved towards ceasing to be the SFRY army and instead gradually developed into a mainly Serb force serving Serbian goals." End of quotation. There are 2 points here. First, the JNA did indeed become a mainly Serb force. By June 1991, the officer corps of the JNA was already about 2/3 Serbian. The commanders of every armoured and mechanised JNA brigade located in Croatia and in the adjoining areas were Serbs or Montenegrins. This reflected the lack of confidence placed in non-Serb commanding officers to fulfil what by that time had become the objectives of the JNA, namely the objectives of the Serbian leadership. That alignment of objectives between the JNA and the Serbian leadership is my second point. Under the Constitution, the use of the armed forces required the agreement of 5 out of the 8 members of the presidency. But SFRY constitutional requirements were bypassed and manifestly bypassed, to the extent that private meetings took place between the Serbian leadership and General Kadijevic, and General Kadijevic. Jovic gives us a number of accounts of these meetings. According to one, on 5 July 1991, Jovic and Milosevic demanded and obtained a significant promise from Kadijevic. Kadijevic promised that the JNA would defend the Serb population of Croatia. This was in July. As you'll hear over the course of this week, the word defend is a distortion of what the Serbian leadership actually intended and what the JNA actually did, a gross distortion. Jovic noted that Karadzic had promised that the JNA would execute the orders, and I quote, of a group of members of the presidency, although they do not constitute a qualified majority. This in the event the presidency was not able to perform its functions and to make the decision on defending the country's integrity. From that time until the end of 1991, and the end of Kadijevic's command over the JNA, Serbia demanded and consistently received support from the JNA. Serbia argues that the fact that this promise was sought demonstrates the independence of the JNA. It doesn't appear to dispute that the promise was sought and obtained. What the promise illustrates, rather, is the contempt and disregard of the JNA command for the Constitution and the SFRY presidency. It also illustrates the close alignment of the JNA by this stage with the position of the Serbian leadership. From mid-May 1991 to 7 July 1991, the Serb presidency did not hold any meetings. This is a time of crisis in the country where it was the primary constitutional organ. But the JNA was deployed along the borders of the territory to which Serbs laid claim, including large parts of Croatia. This was consistent with what Jovic and Milosevic had requested from Kadijevic on 5 July 1991. By then, the transformation of the JNA had been achieved. General Kadijevic himself describes what was happening. At a meeting he had with Milosevic and Jovic on 30 July 1991, he said, "The JNA should be transformed into a military force of those who want to remain in Yugoslavia, comprising at least Serbia, the Serb nation, and Montenegro." And note the reference in this candid statement not only to Serbia, but also to the Serb nation. And here Kadijevic's views on the nature of the JNA, again candidly expressed, and again as recorded by Jovic on 24 September 1991, when he said, and I quote, "Serbia and Montenegro should declare that the military is theirs and assume command, financing the war and everything else. All the generals on the general staff except one are Serbs, and they all support this approach and think the same way." Why did the Serbian leadership not declare at this time that the JNA was a Serbian army? The fact that it did not do so de jure does not detract from the fact that it was a Serbian army de facto. Its rationale for not doing so was purely tactical and presentational. One of the paramilitary leaders, Sešel, of whom you have heard, explained, and I quote, "We must fight for a Serbia that covers all Serbian territories," end of quote. "And we shall call such a Serbia Yugoslavia as long as that is in our interest," end of quotation. I'll say more about the legal consequences of the de facto status of the JNA in my presentation on Thursday. But Sešel, not for the first or last time, really says it all. "We shall call such a Serbia Yugoslavia as long as that is in our interest." The Balkan Battlegrounds report, on which Serbia's pleadings rely heavily, confirms that by midsummer 1991, Milosevic and Jovic were the JNA's de facto political overseers in rump Yugoslavia. Perhaps unsurprisingly, given its reliance on the report, Serbia seems to accept the conclusion that, and I quote, "The army became increasingly Serbianized after the eruption of the Slovenian 10-day war, as conscripts began deserting and the other republics refused to send their biannual intakes of conscripts to the JNA," end of quotation. At the same time, Serbia refuses to confront the fact that the JNA had ceased to enjoy any legitimacy as a federal army. It was seen by many, Serbs and non-Serbs, as following the directives of the extreme nationalist government led by Milosevic, and that perception was accurate. Mr. President, members of the Court, that brings me to the next aspect of the developing role of the JNA. Serbia seeks to present it as playing first a neutral role, and then from September 1991 a defensive role, initially at least in defence of the SFRY. That's a whitewash. Serbia's rejoinder uses revealing language when it characterises the JNA's role in the early stages of the conflict. Serbia continues to claim that the JNA, and I quote, "acted as a federal organ of the then SFRY, and that it was trying to subdue insurgent forces that were attempting to bring about the secession of Croatia from the SFRY," end of quotation. In intervening to prevent Croatia's independence, however, the JNA was not acting as a federal organ. Its actions can be contrasted with its rapid retreat from Slovenia, which was also trying to separate. The opposition to Croatia's independence came from Serbia, supported by the governments in Montenegro and the two autonomous provinces, which had been brought under control of Serbia. In acknowledging that the JNA was determined to preserve the existence of a notional SFRY, including by force, Serbia effectively concedes that the JNA stepped outside its constitutional role as a federal organ. In its rejoinder, Serbia concedes, and I quote, that the role of the JNA in Croatia gradually changed from a peacekeeping force to one of the warring parties, end of quotation. This is a significant concession, even if it's wrong to describe the JNA's role as ever having been that of a peacekeeping force. Serbia adds that the JNA became a warring party, and I quote, "only as a reaction to hostile and criminal actions undertaken by the newly created Croatian armed forces, who started a war for secession against the SFRY, the country the JNA was tasked to protect," end of quotation. Serbia again misses the point. It doesn't seek to defend the JNA's actions on legal or constitutional grounds. Instead, it cites a political objective, patently a political objective of Serbia rather than the republics collectively. The JNA adopted a line drawn by Serbia on what could be permitted to the other republics, without regard to the functioning of the constitution or the democratically expressed will of 3 republics, including Croatia. The point here is that by this stage, the JNA was operating under the effective control of the Serbian leadership pursuing Serbian objectives. The Balkan Battlegrounds report acknowledges this. In summer 1991, the JNA was, and I quote, "acting in the name of Yugoslavia, but irresistibly biased towards Serbia," end of quotation. The report also notes that, and I quote, "after the war in Slovenia began, the JNA dispatched large numbers of troops to the border with eastern Slavonia and elsewhere in Croatia to intimidate Zagreb into backing away from secession," end of quotation. Coming from a report on which Serbia relies, these are strong statements. They confirm that the JNA was acting in accordance with Serbian objectives, Serbian characterizations. These objectives are far from being neutral or defensive. Serbia makes a number of assertions about the extent to which the Serbian leadership controlled or commanded General Kadijevic. It calls them, and I quote, "uneasy political allies," end of quotation. But whether uneasy or not, they were political allies. The relevant point is the role played by the JNA in the conflict under General Kadijevic. He describes that role in his memoir. The objective, he said, was to totally block Croatia from the air and the sea and to secure and hold the planned border of the territory claimed by Serbs. This aligns not with the objectives and interests of the Republic, but rather with those of Serbia and its allies in the self-proclaimed Serb entities in Croatia. And these objectives were not defensive, they were avowedly aggressive. In March, the trial chamber of the ICTY concluded that Kadijevic was a party to a joint criminal enterprise whose common purpose was, and I quote from the ICTY, the establishment of an ethnically Serb territory through the displacement of the Croat and other non-Serb populations. But that's the fact. The displacement can be characterized one way or another, but the fact is indisputable and has been found by tribunals looking at the issue with care. Indeed, Serbia does not dispute this. It simply says that this conclusion must be, and I quote, taken with reserve, and does not prove that the JNA was a de facto organ of Serbia or acting under its direction or control. I'll consider that legal proposition in my later presentation. But as a factual matter, given that the JNA senior command was actively engaged in a joint criminal enterprise with the President of Serbia to take action against the population of one of the constituent republics of the SFRY, only one conclusion is possible. It was already functioning as a Serbian army. Mr. President, members of the Court, I turn to the next issue, the JNA's role in arming, controlling and directing Serb forces. The proclamation of the Serb entities in Croatia in 1990 and 1991 set the stage for the destruction of part of the Croatian population. Serbs were spurred into action by the emergence of radical Serb institutions and by powerful anti-Croat rhetoric, as we have shown. In addition to the JNA itself, a variety of groups were involved in the destructive onslaught against the Croat population. Serbia asserts that it did not supervise or direct these groups, but that is not correct. They were under the control of the JNA. Without the active, extensive and sustained assistance of the JNA and Serbia, they could not have conducted a campaign to destroy a part of the Croat population. I'll introduce the variety of groups that participated in the Serb onslaught, then I'll deal with the JNA's role in arming these groups, then with its direction and control. The groups fell into several categories. First, of course, there was the JNA itself. Secondly, there were the territorial defence forces from the constituent republics, in particular Serbia. Thirdly, there were the groups we've termed paramilitaries. Overall, 32 volunteer paramilitary units operated in Croatia, 16 organised in the Republic of Serbia, 16 operating from Serb entities in Croatia. They were organised not only by the Serbian government, but also by political parties and local police or community leaders. Their members were drawn from the JNA, from the Territorial Defence Forces and from local militia and police. There are some reports that criminals were released from prison solely for the purposes of forming units. We've listed these groups in our pleadings and annexes. Fourthly, there were the forces established by the self-proclaimed autonomous Serb entities in Croatia, the SAO Krajina, the SAO Eastern Slavonia, the SAO Western Slavonia. These included forces described as police and as territorial defence forces. These so-called territorial defence units of the self-proclaimed Serb entities are distinct from the territorial defence units of the constituent republics, which were part of the formal military structure of the SFRY. Also established by the SAO Krajina were special police units known as Militia Krajina. Serbia states in its pleadings that the Militia Krajina were within the framework of the Ministry of Internal Affairs, but were under the authority of the Ministry of Defence. The SAO Eastern Slavonia also established its special police units, the Srpska nacionalna bezbednost, Serbian national security. Along with the Militia Krajina, this was later incorporated into the Ministry of Internal Affairs of the RSK. Like the more heterogeneous paramilitaries, the forces of the Serb entities were ad hoc formations which would have been unable to perpetrate atrocities without JNA support. One vital aspect of that support was the role of the JNA in arming both the forces of the Serb entities and the paramilitaries. In May 1990, this JNA had disarmed the Croatian territorial defence. These weapons were inherited by the so-called police and territorial defence units of the SAO Krajina. More widely, in early 1991, the JNA began arming local Serbs and paramilitaries. Villages with a Serb majority became outposts of the JNA and bases for these newly established paramilitary groups. There is considerable eyewitness testimony and official JNA orders to evidence that this was endorsed at the highest Serbian political and military levels. For example, a letter from Colonel Dusan Smiljanic to General Ratko Mladic, both senior JNA officers, describes how from April 1991 the JNA engaged, and I quote, in the illegal arming of the Serbian people from our warehouses, end of quotation. Between April and July 1991, the letter says, about 15,000 infantry weapons and anti-aircraft guns were distributed to Serbs in the area. And in April 1991, the JNA established a special operation team responsible for, and I quote, the arming of the Serbian people, end of quotation. The letter adds, and I quote, from August to October 1991, we distributed, or to say, pulled out from the Ustash's warehouses about 20,000 pieces of various weapons, end of quote. They included howitzers, bombs and rocket launchers. Two JNA officers describe how the JNA distributed weapons to rebel Serbs across Lika in the summer of 1991. One of the officers explained that senior JNA commanders had authorized the mass arming of Serbs throughout the region. And I quote, during July and August 1991, mostly at night, they transported weapons from Sveti Rok and Stradnik, which was distributed amongst the Serbs in Lika. Usually after a visit of Lieutenant Colonel Smiljanic and General Boric, the Serbs would be armed on a massive scale. End of quotation. Similarly, the ICTY found that in Kordun, and I quote, helicopters were used by the JNA to carry weapons and ammunition which were distributed to local Serbs. In relation to Western Slavonia, a former Serb fighter testified before a Croatian military court that in November 1991, the JNA supplied paramilitaries with arms from a local territorial defence warehouse. A document entitled, and I quote, Request for Ammunition and Other Equipment, end of quote, of 18 September 1991, shows that the JNA supplied arms and military equipment to the so-called, quote, Ministry of Defence of the Republic of the Serbian Krajina, a wholly unconstitutional entity. Other witnesses described how the JNA similarly armed Serb forces in numerous locations across Croatia. This was not the defence of the 1974 Constitution. Serbia presents the self-proclaimed Serb entities as operating independently of the Serb leadership. But that's inconsistent with the facts and with the findings of the ICTY. The Milosevic indictment alleged that Milosevic and other inhabitants and other participants in the joint criminal enterprise, which included high-ranking officials of the self-proclaimed Serb entities in Croatia, and I quote, directed, commanded, controlled or otherwise provided substantial assistance or support to the JNA, the Serb-run TO staff and volunteer forces, end of quotation. In Martic, the ICTY held that the existence of that joint criminal exercise had been established. It also found that the SAO Krajina territorial defence was subordinate to the JNA, and I quote, beginning after the summer of 1991, end of quotation. that the Serbian authorities financed and equipped its Ministry of Internal Affairs, and that its units were subordinated to the JNA for specific assignments. When subordinated, those units would be under the command of the JNA unit commander. In fact, JNA control extended much further than this. Mr. Turnins, to whom I've referred, testified about this control in his expert report. He comments as follows on the legislative framework adopted by Serbia and by organs of the collapsing SFRY under Serb control in order to accommodate volunteers, and I quote, "In order to regularise the de facto situation that existed on the ground, in particular with regard to the presence of volunteer groups and paramilitary formations, legislation was amended. In August and September 1991, Serbia and the SFRY adopted decrees and instructions for the registration and acceptation of volunteers in the TO of the Republic of Serbia and the JNA. In September 1991, the SFRY presidency adopted an order for the engagement of volunteers into the SFRY armed forces. Contrary to the situation during the Kosovo armed conflict 8 years later, volunteers were allowed to join and remain in their own groups during their participation in operations. The order of September 1991 integrating volunteers into the JNA confirms that Serbia had effective control of the paramilitary groups. It's notable that the 1982 law on volunteers, annexed to Mr. Turnin's report, provides that, and I quote, "In view of the rights and responsibilities, volunteers are on an equal footing with military personnel or military conscripts." Mr. Turnins goes on to give the following summary of the unified command structure for operations by the JNA along with other Serb forces in Croatia, and I quote, "Documentary evidence indicates that local Serbian TO units and staffs operated under a single unified command and control with the JNA. The JNA established operational and tactical groups to restore and/or maintain unified and single command and control during the operations, involving the JNA, local Serb TO, Serbian TO, and volunteers paramilitaries." Let me repeat that list. The JNA itself, the local Serb TO, that's the forces of the self-proclaimed Serb entities in Croatia, the Serbian TO, and fourth, the volunteers or paramilitaries. All those forces were under single unified command. The ICTY explored this unified command structure in Mrksic. It observed that in situations where, and I quote, "JNO and TO forces were engaged in joint control to combat operations, these units were subordinated to the officer in charge of carrying out the operation," end of quotation. This command structure was reflected in the JNA's own brigade rules, which stated that the integration of command was achieved, and I quote, "through joint efforts by the brigade command and commands of the brigade's subordinate and other units and staff of the TO operating in coordination with the brigade," that's the JNA brigade. Rule 108 made it clear that the integration of command was to be achieved, and I quote, "on the basis of command and subordination." As the ICTY noted, the principle of unity or singleness of command required that in a zone of operations, in combat action, one commander was responsible for commanding all the military units in that area, including TO and volunteer units, and that all subjects in the area, i.e. all units and their individual members, were subordinated to the one commander. It's clear that in practice, at least at the time relevant to this indictment, the officers in command of all joint combat operations were JNA officers. The ICTY gave an example of how this principle of singleness of command was implemented. A circular issued on 12 October 1991 by General Adzic, the Chief of Staff of the Federal Secretariat for National Defence, affirmed that, and I quote, "At all levels, all armed units, whether JNA, TO or volunteers, must act under the single command of the JNA," end of quotation. 3 days later, on 15 October, the command of the 1st Military District of the JNA, and I quote, again from the ICTY, issued an order to all units subordinated to it to establish full control within their respective zones of responsibility. Pursuant to this order, paramilitary units which refused to submit themselves under the command of the JNA were to be removed from the territory. End of quotation. The trial chamber held that the evidence established, and I quote, complete command and full control of the JNA of all military operations, end of quote, involving Serb paramilitaries and volunteers. I repeat those words, full control. Moreover, said the trial chamber, and I quote, in the final analysis, the JNA, under the quote of Mile Mirksic, not only had de jure authority as identified above, but also had the manpower, armament and organisation to exercise effective de facto control over all TO and volunteer or paramilitary units in the relevant areas. The inclusion of the paramilitaries in this structure is confirmed by some of the paramilitary leaders themselves. The Serb volunteer guards, for example, told the press, and I quote, we are currently under the command of the territorial defence of the Serb Slavonia, Baranja and Western Sirmium region, and they are under the command of the JNA. End of quotation. Dragoslav Bokan was the leader of the White Eagles paramilitary unit, which you will hear was responsible for some of the worst atrocities committed against the Croat population. He explained that an agreement existed that implied that, and I quote, nobody should wear special signs and that all units should be under the direct command of the territorial defence. Only Vuk Draskovic's guard did not accept it. They demanded their headquarters be in Belgrade, which was not accepted. Anyway, we no longer had direct control over our men from the moment they were put under the control of the territorial defence. Finally, let me highlight the close ties of the Serbian leadership and the JNA with another paramilitary leader nicknamed Arkan. The Serb security service of the headquarters of the Territorial Defence of the Republic of Serbia stated that Arkan was, and I quote, paid a special attention to by a large number of ministers and other officials in the government of Serbia and enjoyed especially privileged treatment, end of quotation. The security service of the 12th Corps of the JNA stated in January 1992 that Arkan was openly, and I quote, supported by the Ministry of the Interior, the TO and the Ministry of People's Defence of the Republic of Serbia. But it is claimed that this is so on the direct orders of the highest leadership of the Presidency of Serbia, of the Republic of Serbia, end of quotation. The same JNA document also reports that Arkan was, and I quote, taking part in meetings of the command of the 1st Military District together with the Corps commanders, end of quotation. Croatia's memorials includes a photo of Arkan attending a funeral in the company of Milosevic. The expert report of Mr. Turnins in the Milosevic case, which analyses the command structure of the JNA in detail, cites a letter to Arkan from the mayor of Petrinja in Croatia, which is described as a Serbian municipality. This confirms that the JNA was responsible for arming and feeding Arkan's unit and that it was under JNA control. Let me start the quotation. We agree with the proposition that members of Arkan's unit participate in fighting on the JNA and territorial defence positions in the municipality of Petrinja. The unit will be commanded by a senior officer and the unit will be part of and under the command of the commander of the 2nd Motorised Battalion of the 622nd Motorised Brigade, Bogdan Ercegovac. Arming and food supply are the responsibility of the 2nd Motorised Battalion. That's, of course, of the JNA. I'll deal with the legal consequences of the control and direction exercised by the JNA on Thursday. But those are the facts. A peacekeeping force does not arm one of the warring parties. Yet the JNA armed, controlled and directed all the other Serb forces responsible for the acts that Croatia says amount to genocide, both the forces of the self-proclaimed autonomous Serb entities and the paramilitaries. The evidence is clear, precise and direct. just as you required it in Nicaragua. The evidence I've cited also provides further proof that the JNA was acting as a Serbian army, pursuing the political objectives of Serbia and its Serb allies in Croatia. Mr. President, members of the Court, I'll finish by mentioning the mismatch in strength between the JNA and other Serbian and Serb forces on one side and the Croatian defence forces on the other. Serbia's pleadings make various allegations about Croatia's preparations for the conflict. They allege that the Croatian government started to prepare for armed conflict in mid-1990. In other words, they were the aggressors. But by 1990, rebel Serbs had already begun the unlawful seizure of parts of Croatian territory with the support of the JNA. It was the preparations by Croatia that were defensive. I mentioned that in May 1990, the JNA completely disarmed the Croatian territorial defence. Serbia's pleadings largely ignore this fact, and yet it preceded the defence activities of Croatia. It was this disarmament that rendered necessary the enlargement and arming of the Croatian police. Additional personnel were also required to meet the shortfall in numbers caused by the rebellion of Serbian police officers in the areas of Croatia where the Serb community had purported to proclaim its autonomy. Croatia began these defence activities very much at a disadvantage. The disarmament left the Croatian Ministry of Internal Affairs as the only internal institution in Croatia with weapons. It had only a single armed unit, a Special Operations Anti-Terrorist Force, about the size of a company, and a total of 15,000 rifles or pistols. It was thus the Ministry of Internal Affairs that played the key role in the first phase of the development of the Croatian forces. It enlarged the regular police and organised special police and reserve police units. It also began to organise some company-sized volunteer units during this phase. There were two subsequent phases. On 18 April 1991, Croatia formed the National Guard Corps, otherwise known as the ZNG. From June to September 1991, the ZNG brigades were the only Croatian units fully equipped with small arms, though they lacked heavy weapons. The Ministry of Internal Affairs also began transferring police reserve units to the ZNG to provide it with territorially organised reserve brigades and independent battalions. The final significant player to emerge was the Croatian army itself. This came in the third phase, after the State Supreme Council decided on 22nd September 1991 to establish a main staff of the Croatian army, which absorbed the ZNG command. It's notable that despite the addition of armoured and artillery units at this time and the incorporation of arms captured from the JNA, the ZNG was still, as the Balkan Battlegrounds report described, an infantry-rich, firepower-poor force in comparison with the JNA, which fielded upwards of 1,000 tanks compared with 250 or so available to the ZNG in the 1991 fighting. More generally, the Balkan Battlegrounds report observes that the Croatian forces lacked the firepower to push the more professional and heavily armed JNA out of Croatia. And, quote, in contrast with the JNA, Croatia had little in the way of a military logistic structure and little time to develop one, end of quotation. This mismatch, augmented by the Serb paramilitary forces that the JNA armed and exercised control over, was a significant one. I should add that the victims of the Serb forces were themselves not always totally defensive. They're defenceless. But here the mismatch was even more extreme. The primary defence of towns and villages was often conducted by local men, calling themselves defenders, but sometimes defending their villages with little more than hunting rifles. As you will hear, for example, from Sakir Starmer with respect to Vukovar, the disproportion is a compelling indication that Serbia's intention was not limited to military objectives, but involved the devastation of the civilian population. The intention was to destroy that population in part, because it was Croat. By the time Vukovar fell, the JNA had an advantage of at least 16 to 1 in manpower and of more than 100 to 1 in artillery and tanks. Mr. President, members of the Court, let me sum up. During 1991, the JNA abandoned any neutral role under the Constitution of the SFRY and progressively transformed itself into an army pursuing Serbian objectives. This culminated in General Hadžićević's agreement on 5 July 1991, before the conflict started, that the JNA would act in Serbia's interest and irrespective of the Constitution. By then, Serbia had clearly assumed control over the JNA, which became its de facto military force. You'll hear more this week about the consequences of the relationship between the Serbian leadership and the JNA, including the JNA's direct participation in activities. This included the sustained support for the rebel Serbs in Croatia, provided by Serbia through the JNA and other state organs. It enabled acts which we say were acts of genocide, both by the JNA and by forces under its direction and control. The issue of attribution of conduct to Serbia, to which I will return, should be seen in the context of that relationship between the Serbian leadership and the JNA. Mr. President, members of the Court, thank you for your attention. Mr. President, I would ask you now to call upon Professor Sands, who will address the legal framework for the crucial issue of characterisation that faces you, Croatia's claim under the Genocide Convention. Thank you, Mr.
Thank you, Professor Crawford, and I give the floor to Professor Sands.
Mr. President, members of the Court, it's an honour for me to appear once again before you in these proceedings on behalf of the Republic of Croatia. You've heard some of the context that leads into the terrible events, the details of which we're going to describe to you in the course of this week. My presentation, which will be short this afternoon, will address the law applicable, at least begin to address the law applicable to the present case, which is, of course, the Convention on the Prevention and Punishment of the Crime of Genocide, adopted in 1948. The Convention is, of course, of great significance. The first modern human rights treaty, adopted in that remarkable period immediately after the end of the Second World War. The concept of genocide came into being as a legal term only in the summer of 1945. It did so before any other human rights treaties existed, and it did so alongside the parallel concept of crimes against humanity. Since the Convention was adopted, it has, of course, been subject to judicial interpretation, including by this Court, by the ICTY, and by the ICTR. I'll begin by addressing the emergence of the Convention and the role of this Court in giving effect to its obligations. I'll then set out in some detail the elements of the crime, focusing both on the physical and mental elements, the actus reus and the mens rea requirement, and in particular the meaning of the words in whole or in part, a central element of this case. I will then address the obligations to prevent and to punish, and the other categories of acts specified in the Convention that do not themselves amount to genocide. Mr. President, members of the Court, you need no reminder about the harrowing events that led to the drafting of the Genocide Convention. Its adoption stems from terrible events in the years after 1933. The end of the war, in the spring of 1945, was followed by the preparation of the Statute of the International Military Tribunal at Nuremberg, which was adopted in August 1945, and the indictment of German defendants on the 8th of October 1945. Article 6 of the Nuremberg Statute includes crimes against peace, war crimes, and, newly, crimes against humanity. I should mention that this last mentioned was introduced into the statute on the suggestion of Professor Hirsch Lauterpacht in a conversation with Robert Jackson, which took place on the afternoon of the 29th of July 1945 at Lauterpacht's home in the garden at number 6 Cranmer Road in Cambridge. It was part of Professor Lauterpacht's desire to make individuals and their protection the central unit of international law. The statute made no reference to genocide or the destruction of groups as such. And that was much to the dismay of Raphael Lemkin, who nevertheless managed to get the word genocide and its definition inserted into the indictment, which was adopted in October 1945 and became a central charge in the proceedings. Lemkin, like Lauterpacht, studied law at the University of Lviv, now in the Ukraine, although he arrived 2 years after Lauterpacht had left for Vienna. Unlike Lauterpacht, who was focused on the protection and rights of individuals as such, Lemkin's concern was with the protection of groups. His original work in 1933 addressed this as barbarity and vandalism, but a decade later he decided to create a new word. And in 1943 he published a proposal for the then Polish government in exile in London using the Polish word ludobójstwo, a literal translation of a German word which was Völkermord, murder of the peoples, a word used by the poet August Karl von Platen in 1831 and then by Friedrich Nietzsche in his work The Birth of Tragedy in 1872. By the end of 1943, Professor Lemkin had abandoned the use of the word for one that was more easily pronounceable and created a new one, genocide. This combined the Greek word genos, meaning race or tribe, with the Latin word side, which means to kill. The term was first used in chapter 9 of his book Axis Rule in Occupied Europe, which was published in November 1944, published by the Carnegie Foundation, and you can see a copy of that on your screen. The word offered a reaction against what Lemkin described as a scheme intended to effect a permanent change to the biology of certain occupied areas by killing off the intelligentsia, destroying culture, transferring wealth, depopulating territories by starvation, killing, or other means of displacement. On Lemkin's approach, genocide described a process. It identified a number of steps, from the identification and separation of members of the group to their removal from a territory and, in some cases, their killing. On Lemkin's approach, each step was to be treated as a genocidal act, and the commission of genocide did not require the killing of an entire group, or indeed even a significant part of it. Preparatory acts, in his view, were genocidal. Integrated into the indictment, but not the statute at Nuremberg, the word genocide was first used in an international courtroom on the 20th of November 1945. It was spoken by Monsieur Pierre Mournier, the assistant prosecutor for the French Republic. Later that day, Captain Kuchin, chief prosecutor for the USSR, became the second person to use the term in an international courtroom. David Maxwell Fyfe became the first member of the British prosecution team to use the term, although he had to wait several months until his cross-examination of Konstantin von Neurath on the 25th of June 1946. We are charging you and your fellow defendants with among many other things, genocide, Sir David said, which we say is the extermination of racial and national groups, or, as it has been put in the well-known book of Professor Lemkin, a coordinated plan of different actions aiming at the destruction of essential foundations of the life of national groups with the aim of annihilating the groups themselves. Of the 4 prosecution teams at Nuremberg, only the United States declined to call for a conviction on genocide in its closing arguments, which may well explain why the word was not mentioned in the judgment. Raphael Lemkin was utterly dismayed by that failure, but he did not give up. 2 months after the judgment, on the 11th of December 1946, the United Nations General Assembly unanimously adopted Resolution 96-1, entitled The Crime of Genocide. And this affirmed that genocide is a crime under international law which the civilized world condemns, and for the commission of which principals and accomplices, whether private individuals, public officials, or statesmen, and whether the crime is committed on religious, racial, political, or any other grounds, are punishable. The General Assembly also called on Member States to enact the necessary legislation for the prevention of crime, and then requested the Economic and Social Council, ECOSOC, to undertake the necessary studies with a view to drafting up a convention on the crime of genocide. 2 draft texts of the convention were prepared by the Secretariat, and an ad hoc committee established by the Economic and Social Council before a 3rd draft was subsequently drawn up and adopted by the General Assembly in Paris in 1948. The first draft, which was circulated in May 1947, was prepared by the Secretary-General in consultation with 3 experts, including Raphael Lemkin, and it was published with their comments. The 2 other experts were Professor Henri Donadieu de Vabre, who had been a French judge at the International Military Tribunal at Nuremberg, and Vespasian Pella, a Romanian diplomat. As with all other major international conventions, the negotiating history reveals a number of substantive and definitional issues that had to be resolved before the final text could be adopted for signature. A summary preliminary report of the ad hoc committee provided that, and I quote, "In this convention, the word genocide means a criminal act aimed at the physical destruction, in whole or in part, of a group of human beings." The prevailing view at the General Assembly was that cultural genocide should be dealt with elsewhere, but not all aspects of cultural genocide fell out of the Convention. Article 2, paragraph E, for example, lists forcibly transferring children of the group to another group as a genocidal act. The Secretariat produced a draft under the direction of Raphael Lemkin, which provided that forcible transfer of children to another human group is a form of cultural genocide. So while the term cultural genocide does not feature in the final text of the Convention, one of its core elements at least is listed in the Convention as amongst the methods by which the crime of genocide is perpetrated. In this way, Lemkin's broad vision and understanding of the legal concept of genocide has endured and is reflected in the Convention as adopted. A second area of divergence among the negotiating parties concerned the issue of scale for the crime of genocide to occur and the extent of the requisite intent, which I will focus on in more detail tomorrow. During the negotiations, there were a number of explicit references to the concept of partial destruction. The negotiating committee stated in a preliminary draft of the principles that the Convention should include, as instances of genocide, such crimes as group massacres or individual executions on the grounds of race, nationality, or religion. I emphasize these words individual executions. This drew on Lemkin's approach and the historical experience through which he and the drafters of the Convention and that entire generation in Europe and elsewhere lived. They understood from first-hand experience that the identification of genocidal acts was not a numbers game alone. It was not to be limited to the killings of huge numbers of individuals, or indeed the destruction of groups in their entirety. The meaning of partial destruction was an issue that permeated the negotiating process. The French delegate, Monsieur Chamou, suggested that one individual death could, in and of itself, constitute an act of genocide. At the sixth session of the negotiations, he proposed that the crime of genocide existed as soon as an individual became the victim of acts of genocide. If a motive for the crime existed, genocide existed, even if only a single individual were the victim. Other delegates argued that such an extreme example should not be made explicit in the Convention, but could be covered by the alternative wording of in whole or in part, which was proposed by Norway. Mr. Rafat of Egypt expressed the view that, and I quote, "The aim of the French amendment would be met if the committee adopted the Norwegian proposal to insert the words in whole or in part after the words with the intent to destroy." It is this Norwegian formulation in this context, relating to in whole or in part, that made its way into the final draft and is part of the Convention today that you will have to interpret and apply. The negotiating history makes it absolutely clear that the final wording adopted by the delegates envisaged that the crime of genocide encompasses the destruction of even a small group of individuals, a subgroup of a larger group, which itself forms a part of the whole group. The words in part say what they say. If the drafters had intended to indicate a large group, or a very large group, or a complete group, they could have said so. They could, for example, have used the formulation in significant part or in substantial part. They chose not to do so. Tomorrow I will continue in more detail on the question of numbers in relation to a separate but related issue, the intention to commit genocide, which is the mens rea of the crime. There was at least one other important area of disagreement amongst the delegates, and that concerned the role of this court under the Convention. The original draft of the Convention sent to the General Assembly would have limited this court's jurisdiction simply to matters of interpretation or application of the Convention. The ad hoc committee draft, which was silent on the question of state responsibility, provided that, and I quote, "disputes between any of the high contracting parties relating to the interpretation or application of this Convention shall be submitted to the International Court of Justice." This more limited formulation was not the text that was adopted. Instead, following the incorporation of a text proposed by the United Kingdom and Belgium, the court was given jurisdiction to rule on the question of the responsibility of a state for genocide. The United Kingdom delegate explained that the delegations of Belgium and the United Kingdom had always maintained that the Convention would be incomplete if no mention were made of the responsibility of states. The United Kingdom delegation explained the responsibility envisaged by the joint amendment was the international responsibility of states following a violation of the Convention. This was, and I use his words, civil responsibility, not criminal responsibility. End of quote. the intention of the drafters that this court should be charged with that duty of overseeing the conduct of state parties according to that standard and to hold them accountable if established is evident from the final wording of Article 9 of the Convention, which explicitly refers to the responsibility of states. Those words place a significant responsibility on this court, recognizing that states, as well as individuals, may perpetrate genocide and may be internationally responsible for acts of genocide or for failing to prevent acts of genocide from taking place. The conditions in which that will occur are matters to which I will return tomorrow morning, Mr. President. With your permission, this is probably a good place to break. I thank you for your attention. Tomorrow we will get to the nitty-gritty of the issues that you face. Thank you.
Thank you, Professor Sands, for completing your pleading of today. May I kindly just ask you to check the name of the French delegate, whether it was Mr. Chamon or rather Charles Chaumont, later well-known professor.
I will certainly do that, Mr. President.
This sitting is adjourned. We will meet tomorrow morning at 10 o'clock.